Well, good morning, everyone. Welcome to the Hospitality Law Seminar, Labor and Employment Issues in the Hotel and Restaurant Industries. One of our virtual seminars that we've been producing. Today is April 26, 2022. It's 11 o'clock Central Time. Let's take a look at a few other things we have coming up. We've got our Risk Management and Loss Prevention Seminar, Tuesday, July 26th, same time, 11 a.m. Central. And I think you'll find that very informative if you work in that space. And then we have legal challenges in the contract food service management industry. This will be our second year that we've hosted that one. That'll be Tuesday, November 15th at 11 a.m. Central. These are all virtual, so I hope you'll join us. And then we also want to make you aware of our very cool Hospitality Law Conference that we host annually in Washington, D.C. This year it'll be on Wednesday, October 12th. It's a one-day program. It's a very intimate gathering, small group, usually about 100 folks. But we gather at the Army-Navy Country Club in Arlington, right outside of, it's about 15 minutes from Reagan National Airport. You've got a beautiful view of the Washington Monument. It's just a perfect place to gather and hang out. We're excited to do it again after a couple of years of being absent due to COVID. So I hope you'll join us for that. I promise you the venue is very cool. All right. I'd like to give a special thank you today to the Rimkus Consulting Group. When you need experts for your litigation support, think about them. Hamilton, Miller, and Birthisel, they have a primary offices in Miami, but they work all over the country and a whole lot internationally, particularly in the Caribbean. So appreciate all of their support. And then, of course, as always, Fisher & Phillips, a national labor and employment law firm focusing on the employer's perspective, and happy to have them join us as usual. So thanks, everyone. So we're going to start out this morning. We've got three 30-minute programs for you. The first one is wrongful termination claims and indemnity between owners and managers. It's going to be presented by Jason Bloom of the Hamilton Miller Law Firm. So Jason, he's a partner in the firm, offices out of Miami. Let me tell you a little bit about why Jason brings so much expertise to the table. He's represented hotels, brands, owners, et cetera, in contract and liability claims. But what gives him unique perspective is his work in the insurance coverage space. So he really understands contracts, but he also understands liability, indemnification, hold harmlesses, things like that a lot of folks sign off on, but don't really understand. So we're fortunate to have Jason and his expertise with us today. Ladies and gentlemen, please welcome Jason Bloom.
Good morning, everyone, and thank you, Stephen, for the wonderful introduction. It was nice seeing you just a few weeks ago in Houston, and I look forward to seeing you again in person. Good morning, everyone who's on the call. This is admittedly my first virtual presentation. I hope it goes well. I wanted to discuss, as part of my presentation today, kind of two sides of an issue that I've seen and had been involved in litigation around. And that is wrongful termination and the consequences of that, what kind of forms it might take, the involvement of the EEOC, and then lastly, kind of the crux of my presentation is the way that an EEOC or any wrongful termination claim could implicate defense and indemnity obligations, both between contractors, but also with insurance companies broadly. So we start kind of with the fundamental, the premise, at-will employment. This is something that I remember growing up hearing, that, you know, when I got my first job, it was at will, which meant I could be fired for any reason or no reason at all. It's a mantra that I think is widely accepted in the ethos of American employment, but it's inaccurate. The concept of the at-will employment really started eroding in the 1960s with the introduction of various federal legislation and statutes, and especially over the last 30 years, has kind of taken on its own flavors with discrimination claims, sexual harassment claims, some statutory wage claims, retaliation claims. We'll talk about that next. But certainly, over the last few decades, there's been an explosion in litigation, and you'll see advertisements by plaintiffs-minded attorneys in every state in the country. Have you been wrongfully terminated? And that term, wrongful termination, is really an umbrella term which encompasses many different types of issues which could arise. Next slide, please. So again, broadly speaking, how will a wrongful termination claim manifest? The big ones we'll see is for sexual harassment and or a hostile work environment, race discrimination, retaliation over workers' compensation claims made by the employees, violations of FMLA, wage and hour violations, and whistleblower retaliation. For the purposes of the next few slides, I'm going to focus in a little bit on sexual harassment and or hostile work environments, as well as race, but also age discrimination and basically protected class discrimination claims. It should be noted, and I wanted to point out, because I'm an insurance lawyer, I have to mention wage and hour violations, which is not paying minimum wage, not paying appropriate overtime, overworking your hours. These types of violations are often not covered under your EPL insurance policies. And sometimes, in fact, we'll discuss a little bit later, even your EEOC claims may not be covered under your insurance policies. I strongly encourage everybody who's listening, who has interaction with their risk managers or insurance brokers, to request and review your EPL policies to understand, where am I protected, where am I not protected, do I get an attorney, do I have to pay for an attorney, and if there's liability, do I have to pay out of pocket? Briefly, on harassment and hostile work environment, this means that a claim could come in if an employee is fired, demoted, denied promotions, or forced to quit in both discrimination and harassment claims. And some of the ways you see, or our British friends like to say, harassment claims arise, some of the more obvious examples are sharing inappropriate images or videos with your employees, sending suggestive letters, notes, or emails, which include sexual innuendos, displaying sexually inappropriate images or posters, telling lewd jokes, or sharing sexual anecdotes or histories. These types of things, if it causes an employee to leave or be uncomfortable and it affects their performance, obviously if an employee is propositioned and requests or refuses and is retaliated against, these are all the ways that you're going to see sexual harassment claims present themselves, at least factually. Some of the less obvious I wanted to include in here, especially with the the increase in some of the litigation. There's been circumstances where just physically blocking a person's movements or standing in their way in certain manners has been seen as a hostile work environment. Brushing up against a person, either accidentally, they're going to allege on purpose, but physical contact, staring or looking at somebody's body, following somebody around or paying excessive attention. Certainly in the era of social media, you really want to avoid, especially in the superior subordinate context, following on social media, incessant comments. These type of things can be translated into a harassment or hostile work environment type claim. And then lastly, it's important to mention here that employers have an obligation to not only preclude or prevent direct sexual harassment by its employees, but also an affirmative obligation to intervene if they see it happen by third parties. I represent a number of restaurants and hotels, and the number of stories that come in about that one guest who stays there a lot, or the guy at the restaurant who likes to spend a lot of money, who just won't leave the hostess alone. I mean, this is a scenario that could manifest itself into a harassment claim against the employer. Briefly on discrimination, and again, some of the stuff is fairly obvious, I would hope, at this day and age, but certainly using racial slurs in any context, offensive or derogatory remarks about a person's race or color, display of racially offensive or even insensitive symbols, and then even to some extent teasing and joking, which even the Department of Labor has said, we don't punish or prohibit, teasing and joking, but it's the frequencies. And so if this is happening over and over again, it's something that could expose you to some liability. Next slide, please. So what happens if, and God forbid when, you're faced with some form of a wrongful termination claim? What is the exposure in that context? And these are some of the categories that we've seen in the litigation in terms of the amounts of monetary compensation that employees are seeking. This is not non-monetary. Sometimes they could be ordered to have their job reinstated. This is just the monetary categories of damages that we've seen broadly. Certainly compensation for past services. So somebody bringing a wrongful termination claim will ask a court to award them all the money they're owed for the time that they worked at the place of employment until the terminating event or the force to quit. And that would include, by the way, bonuses and commissions that are earned. Back pay is all the money that the aggrieved employee would have earned from the period following the discharge until the employee finds either new employment or is reinstated with the company. So again, in addition to the money that they've earned, they can claim to be paid for the money that they should have earned in the past. Front pay is starred here because there have been very clever attorneys in certain contexts who have argued that the employee should be entitled to compensation for the period of time between, and again, it's a little interesting, lost future earnings, which represent the difference between what the employer would have earned from his former employer and what he could expect to earn from his future employer. So, perhaps a decrease in value on how much money he's making in the future, but it's starred because speculative damages like this are tend to be difficult to quantify. Interest on the award of future damages. Those interest is always awarded on damages cases. The value of the pension and benefits that the employer should have received. Expenses relating to finding new employment if they have to hire a recruiter, which may or may not have to pay. Moving expenses if they have to move to a new city. And then the two last big categories, which should both be starred, mental anguish or emotional distress, and punitive or exemplary damages. And we'll talk about a case with punitive damages in a few slides. But mental anguish or emotional distress as a liability attorney is something that I abhor. And the reason for that is that it's non-economic. It's whatever a reasonable person decides. So I pulled at least one case talking about the award of mental anguish or emotional distress and found that in a retaliatory discharge action, compensatory damages were in the amount of $94,000, which included $19,000 for lost wages, but $75,000 for mental anguish, and the court found that was not excessive. The employee testified that because of wrongful termination, he became depressed. He had problems obtaining gainful employment. He couldn't pay his bills. His car was repossessed, et cetera, et cetera, et cetera. And the court found that $75,000 for mental anguish in that case was not excessive. However, there are limits on this. This is not going to be awarded in every case. And, several courts have looked at the extent of the conduct being the determining factor. So under Connecticut, for example, mere termination of employment, even if wrongful, is not enough to sustain a claim for what amounts to negligent infliction of emotional distress. Such a claim in that circumstance must be accompanied by allegations of unreasonable conduct, which occurred during the termination process. So aggravating factors here is kind of the key to focus on. And the worse the conduct, the more likely a former employee will be able to argue and perhaps obtain non-economic damages for emotional distress. The big ticket item here is punitive damages. There are various states which say, kind of as a matter of public policy, that termination of an at-will employee in violation of public policy does give rise to an action sounding in tort. And because it's an action in tort, as opposed to just a purely contractual cause of action, punitive damages may be recoverable under proper circumstances. And a few of those states, California, Iowa, Maryland, Nevada, New Jersey, Oregon, West Virginia, Kansas, Massachusetts, these are states where we've seen punitive damages award in a wrongful termination context. Some states, however, restrict punitive damages by statute. Some states find that, essentially what you're alleging is a workers' compensation claim, and workers' compensation in certain states specifically excludes punitive damages. And then a lot of the analysis may depend on whether the employee is suing the employer for a tort or suing the employer for a breach of contract or a contract implied. Next slide, please. I wanted to give just kind of a few examples of recent wrongful termination cases. I think that they present some interesting facts and some considerations. I don't know if anybody attending has personal knowledge of these, and if they do, then I apologize. But the first one I wanted to bring up is out of New York. It's very recent, Sanchez versus Hersha Hospitality. And what happened is an ownership investment trust that owns 16 hotels is currently facing a proposed class action lawsuit. And the reason that it's being sued is because it was using criminal background checks to disqualify certain candidates. And this is an example, perfect example of, a list may not be exhaustive, and some of these things come up in different contexts. So for example, in New York, there's a New York City human rights law that prohibits certain discrimination based on conviction history. And the lawsuit alleged that the defendants ran afoul of the Fair Chance Act by failing to provide the plaintiffs at the time of the firing with a copy and a detailed explanation of the circumstances under which an employer may reject an applicant on the basis of conviction history. And I think it's important to note as employers, the changing landscape, there's on criminal backgrounds and the check the box movement, broadly speaking. You're going to see situations where an employer can and cannot ask certain questions about an applicant's criminal background, these popular movements always seem, great on the front end to certain people, but the implications and the collateral issues that arise sometimes aren't seen until down the road. And so, for example, on one hand, an employer may have very good reasons for wanting to disqualify anybody convicted previously of any sort of theft or major traffic accidents if they're given access to commercial autos. And then down the road, if something happens by one of these employees that were not screened for these issues, causes an accident, that employer is going to get sued for negligent hiring. There's always a balance to these sort of issues, but lo and behold, 2022, New York Investment Trust being sued because of their criminal background screening procedures. I roped in this one, Nicole Duval versus Residence Inn. It's a recent case out of Pasadena, California, and it's an elderly, 50-year-old, I wouldn't say elderly, 50-year-old Caucasian woman who worked at the hotel for a number of years, who was getting joked with and teased by the younger employees at the hotel. She didn't know how to use social media. She wasn't contemporary in her dress and her speech, and this made her feel uncomfortable. Ultimately, she was later suspended for what the employer alleged was job performance, but she turned around and sued, claiming age discrimination. And again, this is not based on any particular conduct by her superiors, but just a work environment where she felt uncomfortable because of her age. The last one I wanted to bring up is a local case that had caught my attention. Maureen Jean Pierre was a Haitian woman who worked in housekeeping at the Conrad in Brickell, Miami. And if some of you are reading ahead, you'll see that big number, $21 million in punitive damages. Miss Pierre wanted to go to church on Sundays. She was a devout Christian. Her employer told her that she needed to work on Sundays as early as 2009, but made accommodations for her to continue working, even though she wasn't working on Sundays. And this went on until 2015. And the hotel decided in 2015 they absolutely needed her to work on Sundays. And because she wouldn't work on Sundays, they let her go. Ms. Pierre sued. She was awarded in a federal jury trial a total of $21 million in punitive damages, along with compensatory damages. That reward was later reduced, but only because in federal court there was a cap on the amount of punitive damages. But these are, again, current examples. Next slide, please. So in addition to the employees directly suing an employer for these claims based on discrimination and or retaliation, there's a federal agency that's charged with enforcing various federal laws that are supposed to protect classes of employees. The Equal Employment Opportunity Commission, also known as the EEOC, has jurisdiction over Title VII of the Civil Rights Act, the Pregnancy Discrimination Act, the Equal Pay Act, the Age Discrimination Act, the ADA, various sections of the Civil Rights Act and the Rehabilitation Act, and the recently enacted Genetic Information Non-Discrimination Act, or GINA, of 2008. And interestingly, this Genetic Information Non-Discrimination Act has two sections that prohibit discrimination based on genetic health information in coverages and genetic discrimination based on genetic information in employment. I don't know that this has come up frequently since 2008 in certain contexts, perhaps more than others, but I think as we advance technologically in the coming years and perhaps decades, the availability of genetic information in whatever form that might take, it's important for an employer to be sensitive around that, and to what extent genetic information is deemed, for example, mental health, lethargy or inability to perform certain tasks. We start crossing into this idea that if an employer is aware of some form of a genetic predisposition, that they cannot discriminate in that context. So why am I talking about the EEOC? And the next slide will give you some example of why. Big numbers. These are, I think, I have here 8 of some of the larger EEOC settlements that we've seen, certainly in the last 10 or 15 years. I'll go through those quickly. The top number here is an EEOC settlement with the California Public Employees Retirement System. And what was California's retirement system doing? They had an industrial disability pension, which was calculated based on the age of the hire and decreasing so that somebody hired at 41 would receive less, would receive 32% of their salary as a pension instead of 50% if someone was hired at 30. And this type of systematic age discrimination resulted in a $250 million settlement by the company. The Henry's Turkey Service, and I'm not sure if anybody's familiar with this, it's the second largest EEOC settlement in history. And it says, I put a quick note, but supervisors were hitting, kicking, handcuffing, and insulting 32 workers who were paid $2 a day to butcher turkeys in a factory. That's not good. And this number kind of reflects, obviously the severity with which those accusations, the circumstances of those present. So I included that. A couple others I wanted just to mention. Texaco was awarded against $172 million settlement, pattern of racial discrimination at the company. Shoney's, some of you may be familiar with this chain, $132 million, June 2005. It was found that executives at the restaurant chain that they were making comments that ethnic minorities were bad for business. They were practices like making specific marks on job applications to indicate whether a candidate was Black was found to be widespread. Workers who didn't appear to be of Northern European descent were denied shifts. Many were fired. And this type of systematic discrimination, if found by the EEOC, will result in big numbers. I included in here another two Publix. This was a gender discrimination suit that women at Publix were found to get the worst jobs in the grocery store. For those of you who don't live in the Southeast, the grocery store chain. And then lastly, Sodexo Marriott services. This was interesting to me because it is again a large number, and what was happening is that Sodexo is an HR company that worked a lot with institutions and specifically schools, and the plaintiffs claimed systematic racism and segregation within the company. And for example, plaintiffs claim that accounts at quote Black company like historically Black universities were staffed only by Black employees, and whether or not there were good reasons for that, business or otherwise, that in and of itself was one of the main factors that the EEOC found and a cause for the award. So I want to talk with the few minutes I have left, because I'm running a little late, about how this shows up in defense and indemnity scenarios. And if we can jump to the next slide. This is sample language from a hotel management agreement, and a little background on how this came about. Major hotel manager was employing back of house laborers through an employment agency, which is common in the industry. And so at some point, the hotel manager decided they wanted to move on from the employment agency that they were using and secure labor through a different employment agency. But it just so happened that every single employee of the fired staffing agency was either Haitian and or African American. And so the fired laborers brought suit against the manager, against the current owner of the hotel, against the former owner of the hotel, and the staffing agency. The claim was also brought by the EEOC. Now, the case did resolve. The EEOC claim resolved, but what ensued was this fight over who were to pay for the attorney's fees. So on the left here, you'll see in the hotel management agreement I highlighted that the operator is required to defend and indemnify the owner only for claims arising out of the operator's fraud, willful misconduct, and or gross negligence. The owner's obligation to defend and indemnify the operator were much broader, including any and all claims arising out of or in connection with ownership or operation of the hotel, but specifically exempting gross negligence, fraud, or willful misconduct. Next slide. So, what was discrimination, gross negligence, intentional, or willful misconduct? Well, the fight over attorney's fees ended up resolving, but it brought up interesting questions, and whether or not the discrimination claim being brought against the indemnitor is willful, gross negligence, or intentional is not a settled question of law. I included here a discussion of Combs v. State Farm and Casualty Company out of California, and the court there said that there is no doubt that intentional discrimination is willful conduct. In Goodman v. Port Authority, the court looked to the allegations made by the aggrieved employees or the aggrieved party, and found that those alleged by the plaintiff were willful. So the allegations of willful misconduct govern the defense and indemnity agreement. And then lastly, in the Second Circuit out of 2002, the court found that it was not gross negligence, intentional, willful misconduct, but specifically because the court adjudicating the discrimination case specifically made a finding that there was no intentional wrongdoing. And these types of issues, whether it's the EEOC settlement or a litigation against the employee, if there's a settlement in that case or an adjudication by the court, whether or not those documents and adjudications incorporate some concept of intentional misconduct or willful misconduct will govern this. Lastly, the very interesting question about whether these types of claims can even be indemnifiable, and it's actually an unsettled question and varies state to state. What do I mean by unindemnifiable? Well, that means can you pass on this obligation to pay for these discrimination claims to the contractor? And the answer might be no. So in Baltimore, the Buck Consultants, the court specifically found that that an agreement between the county and this actuarial company that was performing some of their analysis that resulted in the discrimination claim, that Buck Consultants was not obligated to indemnify or pay for the damages that the county was getting sued for. However, the court did permit the county to seek defense fees for having to defend those claims. So there's somewhat difference there. Lastly, before I open for questions, if I have a few minutes to do so, the question of whether you can even get insurance coverage for discrimination claims is also somewhat unsettled. The idea here is that fines and violations and monetary damages for discrimination is supposed to be corrective. It's supposed to create an incentive on the behalf of the employer to change their conduct. And so there are some states that prohibit states prohibiting insurance coverage for discrimination claims argue that they encourage discriminatory conduct. One of those courts is in Massachusetts stating that. Other states have said that allowing insurance coverage ensures full recovery for the victims, and so then permits insurance coverage for this. Bottom line, folks, on your EPL policies on discrimination claims, make sure you have conversations with your broker and your risk managers about precisely what is and what is not covered. And hopefully you won't find yourself in a situation where you need somebody like me to go fight either with your insurance carrier or your contractors because of discrimination claims. And I thank you for your time. I'll answer any questions.
Wow, Jason, that was great. Thank you very much. Very interesting information. I've got a quick question. We'll see if any pop up in the queue, and we are running just a little short on time. But when you're talking about the EPLI policies, is there any coverage in your experience for tipped wage credit violations?
Yeah, so, and I mentioned that early on, you have to check with the language of your policies, but generally speaking, these types of I didn't pay my workers enough money claims are specifically excluded under these policies, and for various reasons, like, they almost as a contract claim. Owed money tends not to be an insurable event. So most of the time, you'll see carriers declining coverage for some of these, wage claims or tip claims that we've seen come up.
Yeah, I think you've got to be very cautious about those things today. And ladies and gentlemen, I want to emphasize something that Jason mentioned, which is the harassment it's sadly pervasive in the food and beverage and lodging industries. The research that's done at the Hilton College where I teach it tends year over year to demonstrate that it's just very significant amount that occurs in our industry. So I hope everybody's focusing on that and doing your best to prevent that type of thing from occurring. But on that topic, Jason, the third-party harassment I've been hearing about and seeing more of. How about you?
Yeah, I mean, look, in instances of it occurring, especially it seems like since COVID, people forgot how to act. The idea that an employer could be held liable, I think depends a lot on what they know what they do and what they don't do. So, you know, if some guy drunk comes in off the street and grabs a server's rear end and, you know, there's nothing that could have been done to stop that, I don't think that that's going to be as serious. But as I kind of mentioned, you know, if there's a regular that comes in who's gotten very comfortable with the staff and is given kind of special liberties, that's a specific scenario that I think would expose an employer to liability.
Yeah, I agree. I think we're going to see more litigation in that space, whether it's from a vendor, purveyor, country club contacts, the board of directors. You know, remember you've got some challenges there. So it comes down to policy, training, and education, I guess. You agree?
I couldn't agree more. Document, you know.
Yeah, and accountability. I find a lot of people have policies, but they don't hold them enforceable. Yeah. Jason, we're out of time, but thank you very much. And thanks again for a couple of weeks ago. What great information you provided around COVID, potential liability for COVID. That was, you and your team did a great job with that too. Thanks much. The Hamilton Miller Law Firm, ladies and gentlemen, Mr. Jason Bloom. Thanks, Jason. Well, let's keep moving.
Rob, would you like me to share your slides or would you prefer to do them?
I got them right here. I think we're good to go. Hopefully they're showing up there.
Taylor, I think we need to put a CLE survey up, don't we?
We do. Give me 1 second. Rob, while you get that into full screen, perfect. I'm going to put this up for Jason. If you need CLE, just click yes for this, and I'll leave it up for just a few seconds. All right, thank you guys.
Well, that was a great kickoff. We're going to keep it going. Digital intelligence in the hospitality employment environment and beyond. Rob Foster and Brian Feucht are joining us today to talk to us about this. Let's meet our co-presenters.
Next.
So Rob Foster is the operations manager and digital intelligence coordinator for Rimkus in Denver. Rob's an attorney. He's an experienced IT manager. And I love this. He's skilled at intermediating technobabble. I think that's great. And then Brian, I apologize, but is it Feucht?
It's however you'd like to say it. Most people say fight, but that's just because they know me.
Okay, well, I'm going to leave it at that. But thank you for joining us. He's the president of Unique Wire out of Portland, Oregon, with an extensive array of experience in digital intelligence, software development, and if not more importantly, the Marine Corps and an intelligence background. And we're fortunate to have them both. Welcome, gentlemen.
Thank you.
Thanks so much, Stephen. So in all seriousness, we were asked to come in and what was pitched to us was kind of a TED Talk. So we've got a little more time to fill, and Brian and I can go on and on with war stories. But seriously, anybody who's got questions, like, throw them in, and we know you're going to have questions going through this process. We're not going to be able to cover everything. But in the idea of digital intelligence relative to employment scenarios, start thinking about whether these types of questions have come across your desk, or whether your client has kind of picked up the phone and said, I may have a problem. So you ever heard the one where there's a supervisor that was WhatsApping someone after hours? And, oh, by the way, it might have been inappropriate messages. I think Jason talked a little bit about that earlier. How about I was sick that day? Okay. Under the influence, me? Who was around, like physically around, when the injury occurred? Or, the next one down, who was physically around, who was near an area where a customer's property went missing? Or what about the all too common instance where there's email communication and traffic showing up, but that person doesn't work here anymore? Why is that happening? We're gonna let Brian kind of delve into a lot of these pieces here in just a minute. One thing I will note, we have specifically excluded from this presentation, just for the sake of brevity, the how to obtain a device. That is, how to get your hands on the device and how to download it, so to speak. Again, we're happy to address those questions if they come up. That could be its own 30-minute CLE in and of itself. Here's what's really important, and cell phones are ubiquitous, and the thing about them is that they really create a spontaneous interactive diary almost without people doing anything. Now that probably goes a little bit too far, because if we're talking about the WhatsApp messages and those type of things, obviously there's some interaction with the owner of the device and sending the information, but there's a lot of information in that device, in that mobile device, that just exists. Brian will get into that, but some of those things are like locations, the physical location of where the device was. And think about this from a jury perspective. How far is someone typically from their cell phone? It's not very far, right? We all get the shakes if the thing's 3 feet away from you on the desk and you just can't lay your hands on it right away. The actual calls and the call logs, obviously, messaging and the browsing. And folks, I'll tell you, this presentation, if we get far enough into it, is going to scare you a little bit, and you may think about wanting to just get rid of your cell phone. But your phone is tracking health information. In most devices are anyway. The number of steps you take, the elevation that it's at. So, were you on the first floor or were you on the 50th floor? What your heart rate was in some cases. The images stored on the phone, right? Through all different types of apps and media, including the built-in camera. What was the phone? Where was it positioned? Was it horizontal? Was it vertical? Was it laying face down with the screen covered? Was it face up and active and ongoing? How was it unlocked? Did you enter a passcode? Did you use your face or your thumbprint? What applications were you using? And then how did you connect with other things and other parties around you? So this gets into Bluetooth and Wi-Fi and cellular towers and all of those type of pieces. And of course, a heck of a lot more information. And you'll notice as you go through here, it's a mix of information that's deliberately created by a user, but there's an awful lot in here that just plain exists and can be useful in the right case. Now, when I say useful, it can be useful to one party and potentially harmful to the other. So kind of keep that in mind as you think about having to litigate through the employment context. And I'm going to turn this over to you and let you kind of go through the magic.
Okay, so when we talk about getting data off devices in the mobile device space, there's not always the same kind of information that comes off of it. And if you look at the first two, which is a logical and advanced logical, this is some basic text messaging, contact, call history, and media, which is your pictures and videos. You're not getting ephemeral text messaging. You're not getting your web-based emails. You're missing a lot of information there. Jumping up to advanced logical, you get everything that you get in logical, but you start getting some file system stuff. For example, you'll get some of your basic health data, which can be useful, but it's really not that good yet. Where it really starts getting exciting is what we call a full file system. You get an advanced logical, but then you're start getting things like ephemeral email, which is all your web-based email, your corporate emails, your ephemeral messaging, which is going to be your WhatsApp, your Signal, your Wicker, all those quote unquote secret apps that they don't want you looking into. This is where we're able to recover those messages. And this ability is very limited when it comes to new devices. We'll kind of get into that. We're going to get a ton of app data and system log data, including down to the swipe level, activation of your accelerometers. So your phone is tracking how the phone is oriented, but it can also track hard impacts. So if someone has a slip and fall, if they're using their phone, it's tracking the swipe data. And you get a ton of location data, significantly more than the first two. You also get some deleted messages. Deleted messages are a big thing because everyone tries to hide it. You can hide the message itself from the application, but in a lot of cases, that data still lives in the underlying databases that support those applications. The last one is a physical. And a physical, it's the holy grail of extractions. Unfortunately, on modern mobile devices, it's impossible because of the level of encryption that's associated with them. And as far as this goes, full file systems, getting those is the technology is extremely limited to who has that kind of technology to get those, and it's important that you can get them. Next.
Hey, Brian, one thing that I wanted to add here, with respect to digital intelligence, there are companies out there that will say that they can do a lot of these different things. It's really important to, when you're doing your due diligence on those companies, to know what it is they're going to get for you. Unique Wire certainly can get the full file system. Brian, isn't it correct that there's some providers out there that really just stop at the logical level and it ends there?
90% of them stop at the logical and advanced logical because the technology is not available to them. Typically, it's limited to law enforcement and federal agencies. So advanced extraction, again, this is kind of what I was talking about earlier. Telegram, Signal, WeChat, WhatsApp, Instagram, absolutely not available with your commercial extractions. So if you want to get that data, you're going to have to find someone that can support full file system. Ephemeral data. So your Signal, your WhatsApp, you have about 45 days to gather that data. Otherwise, that data is gone forever, and that has to do with how the device overwrites system data to save space and to be more efficient. Location data, a ton of it. You get more in the advanced extractions. Secure folders and encrypted data on Android. If the users, and young people are wonderful about this, they actually make their storage containers your encrypted Knox drive on your phone, or your Samsung Secure Space, or your Zenobi file locker. They actually save the application data to those. So even if they were getting an advanced logical or a logical extraction, they can't get past the security that's associated with the applications because that's the encrypted space. Only advanced extractions are able to do this, and we call that a full file system. Next. To give you an idea of how bad this problem is, everyone can see the dark gray and light graded shading. So iPhone X, all the way up to iOS 13.7 and below, that's available with what we call popular commercial tools. This is your Axiom, your Celebrites, your Oxygen, your Elmsoft. There's a few of them out there. Everything else from iPhone XR all the way down to the newest iPhones, and all the way up to 15.4. 4.1 is, we haven't cracked that one yet. You can't get an advanced file system off. It's absolutely impossible. So you really need to make sure that whoever's doing the extraction is going to get it to a lab. And there's not very many labs that can do it. That can actually get this data that is going to give you the intelligence you need to make a decision. On Androids, next, Rob. It's even worse. So your modern Samsung devices, so that's anything 2018 and beyond, you can get with standard commercial tools. Anything after 2018, you are only getting basically a simple backup, which is not going to get you any intelligent information in order to make decisions. So none of that ephemeral messaging, ephemeral email, any of the stuff that you've got in your secure folders, your Huawei private space or Zenobē second space, you are just not going to get. So a lot of these cases that we see, all the important data is in these containers that are inaccessible by a majority of the forensic companies that are out there. And you need to understand that if you're getting an extraction from a logical or advanced logical, you're actually missing probably about 60% of the data that's going to be relevant to your matter, especially the stuff that's very transactional, that happened closer to the event, if we're talking somewhere between 0 and 45 days. Next.
So I told you that we were keeping it relatively brief, knowing that there would probably be some questions to address at the end. But there are a couple of very kind of key points and some takeaways for you. The first is preserving the data is crucial. As you heard Brian say, with regard to ephemeral information, the WhatsApp and the Snapchat and those type of pieces, that stuff disappears in about 45 days. And so the sooner you can get the information extracted, at least then it's preserved. You can decide down the road, do we need to go in and actually look at it? And that's an important component of digital intelligence. The first thing is get the data, but it doesn't become intelligent until the story is really kind of put together. And obviously with regard to that, the deeper the data, the more the story unfolds. If you go with, kind of that what I'll call run-of-the-mill commercial extraction, you're only getting a portion of the data, and it may or may not include information that's valuable to you. Also be aware that if you're a counterparty to a lawsuit and somebody offers to have an extraction done, there's gamesmanship that can be played in that process. So you want to know what they're going to do and what information they're capable of giving you before you agree to something. We get this question all the time. Well, what if it's a locked phone? The answer, at least with respect to Rimkus and Unique Wire, is yeah, we can overcome that. There's some brute force techniques that can be used to kind of get past the security functions there. Not everybody can do that. And I guess what I would say from a starting point is call and have a discussion with whoever it is you're thinking about for your digital analysis. Have a discussion with them and start feeding them, well, this is what perfect would look like, right? This is exact, like if I could get this information, this would be stellar. Sometimes that's good information and sometimes it's bad, but at least then you know what the story is. Know what your perfect case looks like or perfect data set looks like, and then be ready to have a discussion. And sometimes that's not always possible. Maybe we're past those 45 days, but maybe there are some other ways to kind of get back to what you're otherwise looking for. The next thing I'm going to tell you is it doesn't really stop at the phone, right? The phone, this interactive, spontaneous diary, provides a lot of information, but then it starts sending out all types of connections to other places. Think about the Facebooks and the Twitters and the Instagrams and all of those things of the world. Now you can start to build an intelligent circle around the user of this phone. You know, we start talking about that case that we had earlier, or one of those questions earlier. Drunk, me, it's, you know, if the drunk picture isn't on the phone, it may be out there in social media somewhere, to start tying all these pieces together. So don't limit yourself to just the phone itself. My phone number is at the bottom here, and then I will go on to here. So my contact information is on the left and Brian's is on the right. Again, I think we filled 15 or 20 minutes, give or take. And Stephen, I'm sure there are some questions, so we'll just kind of open it up to you and have at it.
That sounds great. Thanks, gentlemen. Very intriguing stuff, and you are spot on. I'll bet everybody is shaking in their boots. That's interesting and frightening at the same time. So just real quickly, just to clarify, you know, I think working in some of the spaces that we have, most of us are probably under the impression, Rob and Brian, that, you know, only the police have the ability to get into some of the depths that you guys were talking about. But I think what I heard you guys say is, no, we have the ability to get into some of those spaces. Does that sound right?
I would say that law enforcement is one of our larger customers. And we're the only ones that are bringing this to the commercial section.
Okay, that makes perfect.
Legal consent to the device owner, consent to the device, the owner of the data on the device, or a court order is required for us to do this kind of work. It is consent-based 90% of the time, unless you've got a fatality.
Right. And then, of course, you got all your due process that
Correct.
You guys are working through. Yeah, exactly. Well, listen, let me make a practical example real quick. Just coincidentally, a couple of years ago, I was involved in some litigation, and a gentleman had allegedly had too much to drink and had endeavored to walk home and never made it home, apparently struck by a vehicle, and nobody could figure out what had happened to him, Brian. But then they found his cell phone, and via the information in his phone, they could tell when he had left, how far away he'd walked, whether he was on the right path, right, how much time had passed, and also an earlier trip he had walked to, because there was some allegation that he had stopped someplace else to drink, but that was blown away by the information in the phone.
Yeah, actually, it's even interesting. We actually have done a lot of work in gait analysis, and we can actually tell by the person's steps if there's a deviation from their normal walking gait. So if your steps are shorter or they're longer, and based on what distance you're covering, you actually can look at it and with some degree of certainty say that something is impeding their normal gait. So normally, if you take 1,000 steps to walk a mile, we found that people that are drinking, the step count increases to cover the same distance. So not only do you have a geolocation of them being at the bar, potentially, or someone's house, you also have a follow-on analysis of how they're walking, which can provide you a lot of information. And it's not just geolocation that we're looking at. It's actually connections that your phones make to different IoT devices, the Internet of Things devices, that you have no control over. So every time your phone is walking by a Wi-Fi station, even if you don't connect to it, your phone is recording the fact that it was potentially connected, and we can do what we call a BSSID search, and we can actually pinpoint your proximity to a location based on Wi-Fi that you've never even connected to. So there's a ton of data here. We also did one just recently where a person was accused of sexually harassing somebody, And it's sometimes it's not about the data, sometimes it's about the data that's not there. And what was presented were screenshots of this quote unquote sexual harassment that was happening. But what we found was that everything was falsified. And basically the screenshots were generated by two devices. And the only way that you could tell was getting that ephemeral data that was in the secured folders to prove that it was actually being sent to another person. And this actually started out as a criminal case with a civil follow-on. And even law enforcement, up until the point that we did our advanced extraction, were convinced that these were authentic text messages going back and forth between the people. But once we got the advanced extraction, not only could we show that they were fake, we could also show that they were generated by the user themselves. So
that's just fascinating, because the other thing with your extraction with screenshots, you can put things in context.
correct.
Which could be very crucial in an employment case, for sure. I mean, other cases as well, but especially those.
Yep.
Wow. Rob, real quick, you mentioned gamesmanship in some of the issue. Can you give us an example or two of that you've come across, just so that people are a little mindful about that? I know I'm catching you cold, but
No, that's fine. So the gamesmanship comes down to, somebody saying, well, I'll give you the extraction. I'm going to go have an extraction done and I'll give it to you. And they give you a report and it's got a whole bunch of techno babble in it, so to speak. And then it's understanding, did the operator who did the extraction really pull all the data? Because there are, in certain commercial tools, kind of a series of check boxes, right? And you go through and you fill it out and you say, okay, I'm going to hook this iPhone up and I want to extract A, B, and C. I want to omit E. That really doesn't matter to me for whatever reason, and give me H and I at the same time. And so there's a gap in data, but it's not apparent, right? It looks like you have a full extraction. It looks like you have all of this information. Brian and I are actually working on a case right now where we're helping the attorney who was handed this information, on the promise of the counterparty that they were doing a full extraction. We've gone back and helped them file some motions to say, yeah, not so fast. Now, whether it was deliberate or whether the vendor that they had selected, sold them a bill of goods, that's for somebody else to figure out. But you really do have to have an idea of what all the capabilities are in order to kind of know if somebody's gaming the system.
Gentlemen, we're out of time, but thank you for this very enlightening and a bit frightening conversation. And thanks to the Rimkus group for always bringing very interesting information to the forefront for our folks. Great stuff, guys. Thank you kindly.
Thank you.
So here's the survey again. If you need CLE, hit the yes button. And now it's time, ladies and gentlemen, for Mr. California. We're always so fortunate to have Alden Parker join us. Alden, if you don't already know, is a partner out in California, the law firm of Phillips, representing employers. And I'm not kidding you when I say Mr. California. In my 20, 30 years of doing this, I have yet to meet anybody that knows labor and employment law out in California, across the country, but specifically around California, better than Alden Parker. And you can see his credentials. They're exceptional. He's really brilliant when it comes to this stuff. We're always fortunate to have him. I do want to just make one other point about it before I introduce him. He's not just the managing partner of the firm's Sacramento office, but he's also the co-chair of the hospitality industry group for Phillips. And you can see all the folks that he represents there, including hotels and restaurants. Alden, welcome back. You're going to talk to us today about unions and labor relations, and man, there's a lot cooking in that space.
There is. You know, I typically present on California issues for y'all, but I'm not today. I'm really going ahead and focusing on a real national issue that touches every corner of the United States right now. There's a real push that we want to get everybody to go ahead and focus on before the unions really come and eat our lunch. Right now, that's what they're doing over and over again, and we want to be sure that we can end up going ahead and getting everybody ready for that. So I'm trying to advance the slide here, Stephen and Taylor. I'm not sure if I have control of this or not, but
I've got control right now. If you'll just let me know when you're ready to go to the next one, I'll click through for you.
Perfect. So the reason I thought we could go ahead and have this discussion today is because there is a huge push once again to go ahead and organize restaurants, single location, limited service hotels that is spreading across the nation at a really rapid pace. The unions have gone ahead and sat on the sidelines, hoarding their money for the last couple of years with only sort of expenditures on national COVID legislation issues and the like. Organization activities for the last couple of years have been down due to the pandemic. And they have not been expending money on litigation before the National Labor Relations Board or organizing different places. There is that factor and one other factor that have created a storm that are allowing people to go ahead and go out and organize different restaurants and different hotels that are traditionally non-union. The union push in hotels and restaurants is an interesting one. Full service hotels certainly have seen their share of unions over the years. Certain geographic areas with project labor agreements that a friendly local supervisors will go ahead and provide for, will go ahead and see a lot of union activity. But limited service hotels and restaurants traditionally have not seen much. When unionization was at its height in the 50s, we did see some ancillary organizing or secondary pickets of restaurants that typically were frequented by a lot of the manufacturing union labor. But it then died down to have restaurants and limited service hotels really be very low union participation rate, somewhere in the 2%, 2.3%. That compares to what is now a fairly low percentage for unionization workforces outside of the public sector nationwide. That's at around 6.8%. But our sector is one that keeps actually that number down when we start looking at the overall numbers. The reason why it's at 6.8 is because there's plenty of industries that are in the twos, like restaurants, like the limited service hotels. But the factors that have led to this sort of perfect storm are the money that's been sidelined for a couple of years and a decision by the National Labor Relations Board that's allowing organization of micro units. Micro bargaining units have long been a darling for unions, where they've wanted to go ahead and get those, where they can identify very discrete small subsets of employees within a larger property or within a larger business and organize them because they know that they can get the votes, the threshold votes or the threshold petition signatures in order to force an election that way. This has led to really the first major company that's been under attack has been Starbucks. There have been ones and twos in very progressive restaurants out there that you would almost expect to see unionized activities like a Voodoo Donuts. But what you see now in Starbucks is really unprecedented. These numbers change every day. And so I haven't checked the ticker this morning. It's almost like a stock ticker. But they've had 28 elections so far of Starbucks locations. They've lost 27 of those. They've won one election. The more startling figure than that, if you can believe this, they have 250 elections scheduled over the next 2 months. And so Starbucks is losing at a rapid rate. The reasons for that are believed to be numerous, but there is a wave amongst younger employees that have not gone through the cycle of understanding why unions are an impediment to them, or may not be something that advances their career, may not advances their own individual interests, and they haven't learned that lesson. And so they are more susceptible to some of the union's descriptions about other issues that are going on in the general mainstream, like healthcare, like activism, like pushing wages. The unions were very successful years ago in putting a ton of money through the Fight for 15 campaign, targeting restaurants and hotels and certain segments within those agencies that had lower wages. And so they went ahead and pushed very aggressively for a Fight for 15, thinking that it would lead to organizing success, and it did not. It was a top-down approach. They've now flipped that script and gone back to a more traditional organization of those micro units that go ahead and allow for a pretty aggressive schedule for these 21-day fast elections that the NLRB now has. So that's the problem that we're faced with. And so what are we going to do about it? Well, I've gone ahead and put up at least some ideas here that we need to do, at least to get the issue highlighted for us and begin to think about it. One of the most important things is to try and understand the reasons why we prefer to operate union-free. You have to have that within your culture, within your organization. And many of us, since certain segments of the hotel industry and certainly the restaurant industry have not traditionally been unionized, we've lost sight of this, or at least not articulated it well, why we would prefer to operate union-free and why we think that that's a better deal for employees. We also want to understand how unions organize at companies, how to limit their success. We want to think about some proactive and reactive approaches. And what I mean by reactive versus proactive approaches is proactive approaches, even if you don't know that a union is sniffing around your business, happens now. It happens before a petition. It happens well before any sort of union activity, and it helps prevent them from being able to actually crack the door open and get enough signatures on cards to get to the petition level. In that scenario, we have to be very careful about how we communicate our union position. What we are finding is those that simply say unions are bad, they are crooked, you will get screwed in this deal, are losing that battle. They are going ahead and going negative very early before there's ever a union petition, and they're being used almost as a fulcrum for those that are seeking to organize. The proactive steps in communications are highlighting what the company does and what the company offers and why we think we want to go ahead and remain union-free, why we think it's best for the employees to go ahead and have the ability to advance based on their own merit, to get wage increases based on their own merit, to go ahead and seek shifts based on you want the shift, you're a good worker, rather than seniority and just a seniority lockstep approach. The proactive has to be positive. We'll have time, although it's a very short amount of time, for the reactive approach. And the reactive approach happens once that petition happens and occurs during that 21-day election period. And that's when we can start talking with employees about the amount of money that unions take, the fact that they're a business like any other, and they have overhead, and they are going to go ahead and take your money and pay for their legal costs. They're going to pay for their salaries. they're going to pay for their lobbying efforts. And it's not simply a benevolent society that takes money in and then redistributes it out. It is a business. And so what they are doing is they are signing up to be part of a second business for their single job. Those reactive approaches where we sort of highlight maybe the individual failings of a local, the problems that they have had with their pension funds, all of those things come once that petition gets issued. And that's what we're really talking about in terms of those approaches. All of this is intended ultimately to save you some time, some money and stress. Taking a proactive approach and actually being out there talking about why we want to operate union free is important now. And I can't stress that enough. Some people are very concerned about speaking about the issue. And so we tend to try to bury ourselves and not talk about it. And that's really the wrong approach. So Taylor, let's go to the next slide, please. So why we would prefer to deal with directly with our employees when we're fashioning that proactive approach, we need to talk about flexibility. We need to talk about a culture of teamwork to motivate their exceptional performance so they can advance individually. We want to talk about how it's fair to go ahead and deal with employees who are falling behind in a positive way and reward those that are excelling. And all of these things go into a very early discussion, maybe not without even talking about a union, but talking about these concepts for our employees so that that doesn't get lost in the conversation. It occurs to me that with cell phones nowadays and these basically supercomputers in a pocket, your employees are having a union conversation now. There are a certain number of employees, almost undoubtedly in every workforce, that are sympathetic to unions. And so when they see a headline that says Starbucks got organized and lost in Buffalo, or Amazon lost and got organized in Staten Island, they are almost certainly engaging in social media, and they are almost certainly engaging with each other through that medium to go ahead and talk about or celebrate that if they have those feelings. And a lot of it comes from the void that we've created. If you create an environment that talks about wages, benefits, talks about the culture that we go ahead and try to foster, we have some real advantages in our areas. One of the biggest areas that we have advantages are the ability for very young people with small amounts of experience to advance through our companies. We have an amazing amount of advancement. We have an amazing amount of diversity within our organizations, and we go ahead and have tips. And it's interesting, I mentioned tips, they come up so much in hospitality, but tips are an advantage because tips are talking about individual performance. And most unions go ahead and absolutely pool 100% of the tips. And they distribute them across everybody based on hours worked. And so those that excel at earning tipped income go ahead and actually giving up some of that tipped income to people regardless of their level of performance and the level of help that they administer. So in a restaurant, imagine you've got people providing direct table service, both the server and the busser, and the busser does a crummy job as a union member and doesn't go ahead and make the eating area clean, presentable to the customer. They're slow to go ahead and refill water. They are slow to go ahead and bus dirty dishes in between courses. That reflects negatively on the tip when the server ultimately delivers the bill and then collects the payment. The union model ends up distributing those tips equally to the busser and the server. And that is a huge way to motivate your servers to end up going ahead and not accepting a union and the promises that they're going ahead and making. But those really three things, our diversity, our advancement, our culture advancement, and our ability to reward individual performance through tips, are really a selling point that we can go ahead and advance to people for these pre-petition reasons why we would go ahead and want to deal directly with employees. Let's go to the next slide. So I've put up here why some of the employees go ahead and respond to union messaging. Many times it is very similar to a reason why a disgruntled employee becomes a class action plaintiff or a PAGA plaintiff out here in California. They reach out to an attorney or they reach out to someone because they feel ignored, they feel like they got wrongfully terminated, and they get turned into these class action or PAGA plaintiffs. In the union context, it's very similar to that. The biggest problem can be our managers, our supervisors. If they are not trained on how to deal with employees in a respectful way, how to go ahead and make sure that they're applying things consistently so people don't feel like some of their employees, some of their coworkers are getting away with stuff, which is a very union concept, that people can get away with stuff and the overall performance starts to slide. We end up going ahead and seeing people, if they don't feel heard, if they don't feel respected, going ahead and reaching out to unions for the first time. And this really creates an issue. Favoritism is another way to go ahead and see a quick hotline call to a union or engagement through social media. They're getting bombarded with ads based on what they go ahead and search, what they go ahead and put into their wall on Facebook, or what they search on the internet. All of a sudden, these ads from unions, these stories will pop up in their feeds, whether it be Instagram, Facebook. The unions have gotten very, very good at going ahead and using search optimization to all of a sudden tell people about the success of the union at Amazon or Starbucks based on search history. And so sometimes those can be, my manager doesn't listen to me, and all of a sudden the ad will come up. And that's really where we're going ahead and focusing most. Your managers can really make the difference here in creating a proactive strategy of how to remain union free. Let's go to the next slide. So let's go ahead and Taylor, why don't you go ahead and advance? I think this will continue to click through and make the point here about what managers really want, what we want managers not to be. And I was reflecting on the classic workplace violence movie of 9 to 5 and thought about the manager in that instance. I don't think there's a better example while the layered approach of 9 to 5 dealt with workplace violence and sexual harassment. It also dealt with lack of respect for several of the employees with a situation where there was favoritism. And that these ladies felt they had no other choice other than to go ahead and kidnap the individual to teach them a lesson. Nowadays, it doesn't resort to that level of violence typically. What it does is it looks for intermediaries, whether that is a plaintiff's attorney or whether that is a union business agent. That's where they're going. Taylor, let's go to the next slide. I just wanted to offer, a quick primer on what we can and can't say under Section 8C of the National Labor Relations Act and what supervisors can do. There's a ton to unpack and no time to do it in this format. But I wanted to at least start with the understanding of a phrase that we use about know your foe. And the foe is what you can say under the free speech provisions of the NLRA. And that is facts. You can offer facts. You can offer opinions and you can offer experiences. The facts are typically sound a little negative. And so sometimes we save those facts for situations after the petition because they are focusing on union membership. They are down and decline. They are talking about the number of times a specific union may have had an unfair labor practice charge against them. It talks about the facts associated with their pension programs and the underfunding of their liability. It may compare our benefits versus their benefits. But opinions and experiences come up very early in this process. And opinions can be someone's opinion about the benefits of being union-free, the individual advancement, without mentioning what happens at a union or what we think happens at a union. But the ability to go ahead and reward individual performance to advance, the ability to go ahead and have everybody addressed individually rather than collectively when we need to go ahead and maybe make some exception for them and for their individual situation. And then sometimes experiences can be the most important and persuasive. One of the problems here and the deficits we have is that with such a low unionization rate in our industries below the full service hotels, we have a situation where we don't have a whole lot of experiences firsthand within our industry to share, such as, I used to be in a union, here's what I felt the problems were. We don't have that for the most part. Some people have parents or other people in other industries, and they can share that the union promised a bunch of stuff and their experience was that the union couldn't deliver on that. That ultimately we don't see the contract forming in a way that the individual employees voted for. You know, the promises that a union makes pre-petition and during an election are a lot like a high school election, where some student will get up there and the teenager will say, you know, I'm going to have us only go to school until noon, or I'm going to go ahead if you vote for me and get us a 4-day school week. Some promises that they know they can't deliver on. Unions typically will go ahead and do this, and employees have to understand, especially during an election, that the vote only recognizes the union and does not mean that the employer has to agree to anything. And there are a lot of things that we're going to object to, typically on the economics. What you will typically see in a union hospitality CBA is about a 6 to 8% increase in wages, in the hourly wage. You'll see a pension benefit contribution, and then the healthcare benefits get very, very expensive in our industry. What we're seeing is requirements that an employer pay for 85% of the cost of the employee and 50% of dependents. And those costs are not traditional to our industry and become very, very expensive and make us much less competitive in our marketplaces. And so there's a lot to play for here because the costs are just so extraordinary. Taylor, let's go to the next slide. The other idea here that I wanted to introduce, other than knowing the foe, is the tips. And this is what we can't do. So foe is about what you can say, and this is about what you can't say. We can't threaten, interrogate, promise, or spy. Pretty straightforward, but it is one that gets a lot of people in trouble with unfair labor practice charges. So I wanted to make sure everybody understands that concept. Let's go to the next slide. Perfect. I put up a matrix here of solicitation and distribution rules. For sake of time, I'm not going to go over them with everybody. You'll have them in the slide deck for your own use, and I can always answer questions about them. But it really breaks down to whether something is non-work area, a work area, and then whether it is a solicitation or distribution. The distributions and solicitations many times now are coming through social media, coming through sophisticated text chains that get automatically generated by people giving numbers to people. So a sympathetic employee gives the numbers, and all of a sudden a text chain gets generated and people get bombarded with press releases and information. Those cut down to this traditional line. The social media is a real difficult problem now, and one this board is probably going to address, that deal with how and when we define the solicitation and distribution rules as it applies to that medium. Let's go to the next slide. So proactive approaches, I talked a little bit, and this is I think the final slide I have for everybody this morning. We wanted to talk about making sure everybody's aware of possible salting. We have a high rate of turnover And so the interesting thing is many people that sign a petition for an election may end up not being there by the time a contract gets signed, or may not even be there at the time of the election because of the turnover that we have. But we are concerned with this number of, quite frankly, Starbucks decisions, that we will end up seeing people that were former Starbucks union employees then leave that location and end up going to another coffee shop in a hotel, a restaurant in a hotel, or a standalone restaurant, and begin to salt out some pro-union experiences, quite frankly, because they weren't there long enough to experience both the good and the bad. They may simply talk about the feeling they had at the time of the election, and then they weren't there for any of the battles over what the organization looked like by the time a contract came around and created predictive scheduling, caused reductions because of the enormous costs in hiring employees, et cetera, et cetera. You want to go ahead and use these approaches. I'm not going to go through each one of these, but they're valuable tools to go ahead and look at proactive approaches. I think that the main thing is making communications a priority. Don't shy away from this conversation because it is already happening all around you. And if we're silent on it, we are allowing other people to guide and direct these employees in the way that they want them to go. That is an extraordinary problem. And 21 days for an election cycle is not enough to undo and unring that bell if we really haven't done the work ahead of time and creating the positive themes about why our workplace works better as a union-free environment. So Taylor, if you can go to the next slide here. So I'm certainly happy to answer any questions anybody has. I'm sure there's a few. I know we started a little late, and so we're running into the next half hour, but I'm happy to make myself available and chat with anybody on this issue.
Alden, that's great info. Thank you very much. And listen, when Alden volunteers to stay and answer some questions, he's in Hawaii, so there's some real high value here to his time. But Alden, real quick, and perhaps I missed it, but could you give a very practical example of the difference between a solicitation and a distribution?
Sure. So a solicitation is typically, it's a little bit like a defamation claim, and the difference between libel and slander. Solicitation is something that goes ahead and is typically oral, where someone is talking with someone and soliciting them to be part of the union, to go ahead and organize and that type of thing. And if it's done off work property, it's certainly fine. If it's on work property, it's typically not, unless you've built in an area with a project labor agreement that allows them to go ahead and do that. We have some very active places where hotels are seeing very aggressive project labor agreements due to the local political environment. And they have to turn over employee names when they get hired and contact information. They have to go ahead and allow the union unfettered access to the place at any time just to get the property built. The distribution is typically thought of as something that is either an electronic writing or a handbill in the olden times. But now it's typically an electronic piece that will go to an employee and be delivered to an employee by some mechanism, whether that's social media or texting.
Very helpful. Thank you. Question. We've seen Starbucks. We've talked about that.
Yep.
We've all seen Amazon, what happened there, and the tactics that were employed. But where are you also seeing on the hotel and restaurant space significant activity?
Well, so right now, I think it's Unite is the union that is organizing Starbucks, and they seem bent right now on the coffee shops. They had a previous model from a lot of the sort of hipster one-off coffee shops that got unionized in a micro unit, and they're employing those tactics in Starbucks. And they think that they can get a foothold and then go out from there. But the activity we think is mostly going to be in your quick service and your QSR category for the restaurants. We think that those employees are more susceptible to the union's approaches. The potential for upward mobility and higher wages is a little bit locked in those concepts. And so you can top out very quickly, and they think that they have a real in there. We think family dining, white tablecloth are less susceptible there. The organization of the non-full service hotels so far is coming through project labor agreements, and they are attacking aggressively through city councils and through county supervisor levels to go ahead and institute in a vacuum a PLA that then allows a union in the door and a real foothold. And that is really targeting those sort of travel brand hotels that are not full service. Now, a lot of people ask me nowadays, is there a full service hotel left? Because the pandemic has done such a number on our industry that we've had to go ahead and limit services. And we hope that maybe different customers, different patrons will go ahead and adapt to those more limited services. But right now they're going after the travel hotel industry, the limited service hotels.
Yeah, you know, in Houston, it was a full service hotel, but it was affiliated with the convention center. And of course, the city was a partner in it. And so they did, the union was included in that concept like you're talking about. So yeah, that's interesting.
Well, and the micro bargaining units, for instance, if you are a full service hotel, you may sort of stem the tide right now to, you know, some of the traditional areas that have been, that have been organized, your housekeeping. Sometimes banquet facilities get organized within the full service hotel.
Yeah.
The micro bargaining units are really going to allow them to also go over, let's say you have a little coffee shop inside your full service restaurant, or you have a certain segment that's remained union free and sort of under the radar, and no one's thought of it as a bargaining unit. That could be the individuals that work a pool at a resort or the spa, and you could really see a real push for those micro units to be organized.
Yeah, you know, the entire food and beverage aspect, right, could also be a target, I would think, especially given Unite Here's success with food and beverage areas. You guys thinking that, or no?
Well, that's been the traditional concept has been, we'll do better with food and beverage all put together. Okay. We think we're going to be able to go ahead and win those elections if food and beverage isn't carved up. What the union strategy now with the micro bargaining units is they're carving them up, and they're carving them up with your individual service areas within the larger food and beverage. And so they're organizing your morning coffee kiosk. They're going to organize your spa. They're going to organize your dinner house separately, because they think that divide and conquer strategy is the one that's going to win.
Interesting. Well, I want to share a quick story to emphasize what you talked about the culture, and then I've got one last question for you. But Alden, you've probably heard me talk about this 20 years ago, maybe even 25 now. I used to take a lot of students down to Aruba, yep. And they had 11 major hotels down there. One was the Hyatt, lovely hotel, but the others were nice as well. But all 10 of the hotels were all unionized, but the 11th, the Hyatt, was not, and the director of the union was just beside himself because he couldn't get it. And so he said I got to know him. His name was Anselmo Pontilius. He's a great guy. Anyway, he said, go over and ask those employees over at the Hyatt why they're not unionizing with me. And I said, sure. So I asked, and Alden, to a person, they said, why do we need a union? They treat us fairly and kindly. And that Hyatt was often voted the top Hyatt in the brand. Yep. So it just goes to show you can do the things Alden's talking about. You can. Culture really matters.
It really does. I mean, if we try to treat our employees, if our managers try to treat our employees with the idea like we want them to treat our guests, yeah, that really flows down to a great experience for the property. And it typically leads to better feelings, and that why would we vote union? We're good.
Yeah, to emphasize that point, some of my talks, I'll say to people, if you want to know how your employees are treating your customers, you just have to ask yourself how you are treating your employees, right? Because it's almost always the same. Now, there are those wonderful people that can sustain, the bad culture and still deliver the excellent customer service, but for the most part. So Alden, just real quick, you've been doing this a lot. Telltale signs that a union is sneaking in.
So the biggest sign is you used to, as a manager and a management team, used to be able to have a lot of conversations with the employees, and all of a sudden it's gone silent. It is akin to those science fiction movies where the large tsunami is coming to swamp the coast, and all of a sudden the birds disappear, the noise disappears, no one can find a fish, and you have dead silence. When that silence comes, you have employees that are talking about a unionization effort. And as long as the communication is happening, employees feel that they can be heard, go to people and seek individual rewards for their performance. Generally, if that conversation is going on, even if it's about complaints and about issues that are coming up, we want to hear that. When it goes silent, the tsunami's coming.
Great insight. Thank you, Alden.
Appreciate it very much.
Yeah, let's pop that CLE survey up real quick so that everybody with us can get that credit. Well, thanks for joining us today, ladies and gentlemen. Again, thank you, Alden. Thanks to all of our other speakers, Rob, Brian, Jason. You guys were terrific. Really appreciate the information that you shared with us. True thought leaders in the space. Can't do these things without you guys. Greatly appreciate it. Look forward to the next one. Everybody have a wonderful day. And remember, these programs will be on demand. And Taylor will get a note out to everybody and you'll be able to view it then. Thanks for joining us today. Bye for now.